And continuing on with our video series about petty and grand theft, today we're going to be talking about the theft defenses, or how do we defend these type of theft cases in the state of Florida. My name is Adam Rossen, owner and founder of the Rossen and Law Firm. We are expert criminal and white-collar defense attorneys. I'm a former prosecutor, and we've handled thousands of these cases. So the first thing that you need to remember is that it's the prosecutor's job to prove you guilty beyond and to the exclusion of every reasonable doubt. So as we're defending these cases, it is not your defense attorney's job to prove you innocent. And there's a huge distinction with that. What that means is the burden, the responsibility, the pressure is all on the prosecutor to prove their case. All right that we need to do, right? Well, really, we don't have to do anything if they haven't proved it. But the best defense attorneys, we create reasonable doubt, right? We convince a jury, if we're going to trial, of just one reasonable doubt, and then we win. So we don't have to flip this around where you're proven innocent, found innocent. So in a lot of these cases, we do have the upper hand or the advantage. And one of the common defenses that we use is, well, lack of intent. In our other videos earlier, we talked about intent as one of the elements, right? The essential elements of any type of theft case. Well, have you ever made a good old-fashioned mistake before? Have you ever been distracted on a phone call or were texting in a store, and maybe you left the store without paying for some of the items because you were distracted or just, running around? You got kids, crazy kids running around, and you're just trying to get out there and make sure that the kids don't, hurt themselves, right? Or get run over, in the parking lot, right? These things happen. What if there's a business deal that goes bad, right? Is that a crime? Well, in most cases, no, especially not if there's intent. Business deals go bad sometimes, right? That's fine. Of course, it's not the intention for them to go bad. It's, it's a mistake. It's, life, right? There's ups and downs, but they would have to prove that you basically committed fraud through the business, or that you had done things with the intent to steal or to get extra money that was not yours, or whatever it may be. And so that's what you have to really understand, is that very first element, the criminal intent, right, to deprive somebody else of their goods or money. And it's very hard to do in the context of businesses. And a lot of times those are civil cases. You can sue somebody for bad business making decisions, for maybe negligence in the way that they handled their business operations, but that does not make it criminal behavior or a crime where you could be facing jail or prison time. And it's very important to make sure that you have a defense attorney that can go ahead and push for those issues, if you're being investigated or charged with a theft case. One of our biggest ways to defend these type of cases is to really attack the value of the goods at the time of the theft. So it's not how much the goods were originally. It's not how much the goods were at the trial. It's what was the value at the time of the theft. And for this is a great defense for if there's items or goods, not so much of a great defense if we're talking about bad business deals. But remember from the previous video where we talked about the elements of the crime, it is the current fair market value of the goods at the time of the theft. That's the most important thing, and that could be a huge difference between a misdemeanor or a felony, or the different levels of misdemeanors or different levels of felonies. And an experienced white-collar defense lawyer will know how to attack the value. So when we're talking about value, replacement value is not the standard. The standard is current fair market value at the time of the theft. And this comes into play a lot, not just with goods, but specifically electronics. All electronics, they lose value right away, very quickly. The pace at which electronics get, right? You buy an iPhone and 6 months later, right, it's already lost tremendous value. By the time the next iPhone came out, well, the values tank. So, right, let's say 2 years ago, you purchased an iPhone and I don't know, let's just say it was $1,000. and then 2 years later, your friend Bobby steals it, right? Well, first of all, not a great friend, but what was the value at the time? It's not, oh, I need a new iPhone, so I paid $1,000 for it 2 years ago. It's $1,000. It's what was the current fair market value at the time that you took my iPhone, right? I can guarantee it's going to be a lot less than $1,000. And in that particular case, what may try to be made into a felony would only be attacked and would be attacked and brought down into a misdemeanor case. So obviously you need the right attorney that knows how to do these things, and it could be a huge difference between prison and jail, or a convicted felon or not, or not eligible for a diversion program and eligible for a diversion program. Well, what about cars? Cars lose value the minute you drive it off the lot, right? And a big question when we're talking about trial, remember, it's not our job, the defense attorney's job, to prove what the fair market value was. It's the prosecutor's job to prove, right? Remember, what the current fair market value is. And we all know, and I want all you folks to know and understand, is that there's a huge difference between what you know happened and what you can prove happened in a court of law under the Florida rules of criminal procedure and the Florida rules of evidence, right? Big difference between what you know and what you can prove. So yeah, again, going back with this iPhone, okay, if Bob is the alleged victim, well, he can't just say in a trial, I paid $1,000 for that iPhone 2 years ago. First of all, it's not admissible because it's hearsay. Second of all, again, we're not talking about the current fair market value. And if Bob was to try to say, well, I had to buy a new iPhone to replace that one, and it cost me $1,000, again, it's not admissible. He's talking about replacement value. So how do the prosecutors actually prove these cases? Well, in order for them to prove it, they're going to need an expert witness. And that expert witness is going to need to talk about the depreciation of the value of the goods. And there's, a few different guiding principles for those. Well, number one would be original market cost. Number two would be the general condition and quality of the items, right? Was this an iPhone? There's a big difference between an iPhone with a cracked screen and an iPhone without a cracked screen, right? How much was this a iPhone Pro Max, big screen, right? Or was this the lower level, smaller iPhone, lesser camera, right? Original market cost matters and is going to be involved with that. And well, how much time was there since the original purchase? And that expert's going to need to give a percentage of depreciation based on all those factors. And practically speaking, in cases of this magnitude, very rarely will the prosecutors have an expert witness, right? They will if we're talking very complex white-collar theft or white-collar fraud cases. But for the examples that I gave you, which are still serious felonies, right, they're not doing this. So the real question is do you just hire any lawyer that doesn't know specifically how to defend these type of white-collar cases? Or do you hire criminal defense lawyers that are experts in white-collar law that know exactly how to defend these? That's a big thing. And that's why one of the reasons we make these educational videos. Another part of how we defend these cases, and advice that we have for people is, what the police are going to do is they're going to try to talk to you, and maybe they read you Miranda, maybe they don't, but they're going to try to speak to you and get maybe an admission or a confession. So we're always looking at trying to attack and defend, these admissions and confessions. Were your Miranda rights violated? Most of the time, people don't know when their Miranda rights are violated. Most people think, it's when the handcuffs come on, if they've ever watched Law and Order. Well, that's not the way it is. Miranda is custodial interrogation. So the first element is custodial, custody. Are you free to leave? If you could say to the officer, hey, you know what? I just want to go home. Have a nice day. Goodbye. Well, then you're not free to leave. Anything, right? And if they say no and you're not free to leave, well, then if they're going to question you, which is the second element, interrogation, or anything that would lead to an incriminating response, well, then they have to read you your Miranda rights. Even something like, Oh yeah, a bunch of iPhones went missing there, huh? What do you think about that, right? That's a Miranda rights violation if they don't read you your rights. Because even though that might not be an exact question or an interrogation, it's a statement that would lead to an incriminating response. And so since most people don't know when their Miranda rights are violated, right? We believe it's always better to not talk to the police and make sure you have a lawyer on your side, a lawyer that knows what they're doing on your side as early on in the process as possible. Another way that we defend these cases is we attack the investigation. We attack the police investigation. And a lot of these are white-collar cases that are handled by regular police officers. Okay? There's oftentimes a lack of evidence. There's lack of video if we're talking about maybe things at stores, right? We've had many cases where police have made either no effort or a half-hearted effort to actually speak to our client, maybe not to get even a confession, but to hear their side of the story. And if they make this half-hearted attempt, right, and really don't do much, well, what kind of investigation is that? That's not the standard of policing that we should expect when somebody's life, liberty, and freedom is on the line. And they'll just go out and put a warrant out, right? And then we'll have a client who gets arrested 6 months or a year later and goes, I never got a call or a voicemail from a police officer. They never showed up wanting to talk to me. And imagine that if you're innocent, right? Or it's a good, genuine, business dispute. And then before you know it, a year later, right, you're driving and you get stopped for speeding and you get hauled off to jail in front of your kids for an old warrant on these charges that you never even knew you needed a lawyer or to defend against. And we say these stories and examples because they happen. They happen quite often. So hopefully this gives you folks a really good idea of how we defend cases and the right way to defend these type of theft, petty theft and grand theft cases in Florida. And if you continue to like this information, we really appreciate it. Like, subscribe to our channel, give us a comment down below. We read all the comments as well. And you can schedule a free strategy session at any time, 754-206-6200.